Will the Senate approve the nomination for confirmation of Honorable Justice Kudirat Kekere-Ekun for appointment as Chief Justice of Nigeria? Those in favor say aye. Aye. Those against say nay. The ayes have it. The nomination of Honorable Justice Kudirat Kekere-Ekun for appointment as Chief Justice of Nigeria is hereby approved.
My name is Kudirat Mutomori Olatokunbo Kekere-Ekun. I was born on the 7th of May, 1958 in London, UK, to the family of Alhaji Senator H.A.B. Fasenro of Erelu Square, Isaleko, Lagos, and Mrs. Winifred Laiwola Ogundimu, née Savage of Olugbo area, Lagos, both of Lagos Central Senatorial District. I'm happy to say that my father was once in this hallowed chamber. And Corona School Ikoyi, from where I moved to Queen's College Yaba for my secondary education. I obtained my ordinary level school certificate in 1974 and my higher school certificate in 1976. Of Lagos in 1977, and I graduated in 1980. Thereafter, I proceeded to the Nigerian Law School, and I was called to the Nigerian Bar on the 10th of July, 1981. After my call, I proceeded for the one-year compulsory national youth service. I served in the old Bendel State, now Edo State, and I served as a state counsel in the Ministry of Justice Legal Drafting Department. After my youth service, I proceeded to the London School of Economics and Political Science, where I obtained a master's degree in law. Thereafter, I obtained the master's degree in 1983. And from that time, I was in private legal practice until 1989, when I joined the lower bench as a magistrate grade 2. I rose to the position of Chief Magistrate grade 2, and from there was appointed a judge of the High Court of Lagos State on the 19th of July, 1996. Shortly after my appointment as a High Court judge, firearms tribunals. I chaired that tribunal from 1996 until 1999, when those tribunals were abolished. At the same time, I was also carrying out my regular duties as a judge of the High Court. I had several ad hoc assignments during that time. Two of them that are quite worthy of mention is I was a member of the committee that drafted the Lagos State High Court Civil Procedure Rules in 2004. Those rules brought in a lot of reform in civil procedure. They introduced new concepts such as front-loading, where you file all the documents you intend to rely on along with your originating process, as long as witness statements on oath, so that it will cut down the time spent on trial by starting immediately with cross-examination. We also introduced compulsory reference to ADR, and those rules became the model for all the states of the Federation. Another innovation while I was in the High Court was I was a member of the steering committee of the Lagos State Multi-Door Courthouse. That is the first court-connected ADR center in Africa. That model has also been adopted across the Federation to reduce dockets and speed trials. From the High Court, I was elevated to the Court of Appeal in September 2004. While at the Court of Appeal, I served in various divisions. I served in Kaduna, Port Harcourt, Ibadan, Makurdi, and Akure divisions. I was the first presiding justice in the Makurdi division of the Court of Appeal. I set up that division of the Court of Appeal. I also served on the Information Technology Committee of the Court of Appeal. By the grace of God, on the 8th of July 2013, I was appointed a Justice of the Supreme Court of Nigeria. I was the 5th female to be appointed to such a position. In the course of my career as a judicial officer, I have always strived to maintain my integrity, to uphold the rule of law, to ensure that I do justice in all the matters that come before me. Some of these positions that I have mentioned, I believe, have also shown my leadership qualities. Presently, I am the chairman now of the National Judicial Council, but I had served as the vice chairman of the National Judicial Council and also the chairman of the interview committee. I'm also on the board of governors of the National Judicial Institute and chairman of the education committee. I also serve on the Legal Practitioners Privileges Committee. I'm also a member of a subcommittee of the Body of Benchers that looked into conflicting judgments, the challenge of conflicting judgments. I have also received many awards for my work, my dedication. I've been honored 3 times by the Lagos State Judiciary. I've been honored by the Women Lawyers Forum and so many others. By the grace of God, I was conferred with the national honor of Commander of the Order of the Federal Republic in October 2022. I am a life bencher. I am a fellow of the National Judicial Institute, a fellow of the Nigerian Institute of Advanced Legal Studies, and also a fellow of the Dispute Resolution Institute, International Dispute Resolution. These are my credentials, and I stand before you today with a pledge to do my best to uphold the integrity of the judiciary, to uphold the rule of law, to ensure that we defend the Constitution, and to work for the service and interest of all Nigerians. Thank you very much.
What would you do when confirmed as the substantive Chief Justice of Nigeria to ensure that you uphold, or we all uphold, or you uphold the integrity of our judiciary? Nigeria want to hear. If, by the wisdom of the Senate, if confirmed, what steps are you going to take to ensure the independence of the judiciary so that our quest to achieve a just and egalitarian society will be achieved and will not be a mirage? In view of the controversy and the heat generated with regard to contestation for power that normally ends in our courts instead of the people deciding it, it's like now it is the courts that decide who governs as opposed to the people. So there is serious contestation for power, and the battle is taken to the courts. And as a result of that, in order to insulate the judiciary from the vagaries and vicissitudes of this political influence and what have you, there is a school of thought to the effect that there is need to create a constitutional court that will be vested with the jurisdiction to determine election-related matters. So I want your opinion on this.
Conflicting judgments of court. My question, therefore, is, what is your view about this menace, not only in terms of courts of coordinate jurisdiction, but also within the same court? And how do you intend to tackle this problem?
When you are talking of autonomy, independence, you must carry everything. It must all be inclusive and also bear the consequences. And so I'm asking my Lord, do you still stand by that, or there is need for reconsideration? Because capital infrastructure is very, very important. It's very, very important if you want to be independent. That has gone, and I'm sure Her Lordship was on that panel, if not presided over that panel. So you are now the CJN, and I have concern about this capital infrastructure, because without it, there is no independence. There is no independence, and so you cannot be absolutely be said to say that you can work without influence from outside.
People tend to prefer talking about forum shopping to file cases before Federal High Court, particularly if it's a case in which you believe the state governor or the state government may have an interest. And how we deal with this, how the Chief Justice of the Federation can encourage judges in the states to show the same level of courage to pronounce where it's so discovered that a state government or a state interest, a state governor has crossed the red line. But people should feel able to go to a state high court and get justice. I don't want to rush to federal high court because of the fear that judges, in many cases at the state level, don't want to enter judgment that will be offensive to the state executive. That is recently in the state, and for obvious reasons, I won't mention the state. The National Judicial Council approved the appointment of new judges, which is in line with the Constitution. But the state governor in Benin decided, I didn't mention him, I mentioned a city. A state governor in Benin refused to swear in. Excuse me.
You are protected. You did not mention the state. You only mentioned Benin.
Thank you, Mr. President.
Benin is not a state.
That's right. So, as we speak, those judges were not sworn in, even though they have been cleared by the National Judicial Council. When I was a governor, sir, there was a case, a judgment against the state government. But because the governor has immunity, the judge decided to convict the Attorney General for contempt of court. So I'm like, if a state governor disobey a ruling of a superior court, and because the governor has immunity, there is nothing you can do, I would have expected that the Attorney General would be charged for contempt of court or showing disrespect to the National Judicial Council, so that the discretion we exercise should not be abused.
6 years ago, Your Lordship, I had the opportunity of visiting a political friend in his office, and he opened his box and brought 5 expurgation orders in advance. Expurgation orders in advance, and from a competent court of jurisdiction in this country. And it makes me wonder how that is possible. And you could see within the by the time I met him, he was using these expurgation orders. All they were doing was to fill in the gap, fill in the dates. And he has assessed these expurgation orders in anticipation of possible problems by political opponents. And believe me, my Lordship, those orders succeeded at the end of the day. Now, the question that I would like to ask you, is the hand of the judiciary tight in the possibility of not meting out sanction Or do you need an intervention of legislation in making sure that such irresponsibility is actually made by a law of the National Assembly, making sure that it's criminalized? What's your opinion about it?